Trade References Committee. This public hearing is in relation to the committee's inquiry into the Commonwealth's treaty-making process. Copies of the committee's terms of reference are available from the Secretariat. I welcome everyone here today. In the room today we have Senators Ludwig, Fawcett, Back, Gallagher, Whish-Wilson and McEwen. This is a public hearing and a Hansard transcript of proceedings will be made. Before the committee starts taking evidence, I remind all witnesses that in given evidence to the committee they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. I would like to emphasise that while the committee prefers all evidence to be given in public, under the Senate's resolutions, witnesses have the right to request to be heard in private session. If you would like any of your evidence to be heard in camera, please don't hesitate to let the committee know. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. As noted previously, such a request may be made at any other time. I remind people in the hearing room to ensure their mobile phones are either switched off or turned to silent. I welcome representatives from the Australian Council of Trade Unions, the National Tertiary Education Union, NTEU. And for the Hansard record, could you each please state your full name and the capacity in which you appear today?
Jeannie Ray, National President of the National Tertiary Education Union. And if I say my colleague, Dr Kwok, is only just getting in through the public area at the moment because of the 9 o'clock opening.
I'm Ged Kearney. I'm the President of the Australian Council of Trade Unions.
Andrew Detmar, the National President of the Australian Manufacturing Workers Union.
Thank you. Now, does each or one of you want to make a brief opening statement before we go to questions?
Yes, Senator, I'd like to make a brief opening statement and then my colleagues will as well, if that's all right. Thank you and good morning, and thank you very much for the opportunity to address the committee. We believe this to be an issue of national, political, economic and social significance. And I'm sure you know that the ACTU represents just under 2 million workers, and our affiliates cover all sectors of the economy across all states and territories. And as you have heard, I have 2 of our wonderful affiliates with me today. And Dr Ged Kearney will join us shortly, hopefully. He's on his way. The ACTU, of course, supports international trade, but trade that's based on the principles of fair trade, which can be a tool, of course, for raising living standards through economic cooperation and growth, through improved social protections and core labour rights, through the implementation of sustainable environment standards and adherence to human rights conventions and democratic values. The ACTU believes that trade agreements should retain or enhance the autonomy of government in Australia to design and implement policy in key areas. But we insist on a democratic and open process for trade agreements. Meaningful civil society engagement is also important. I'll just take a minute while Dr Jen has his seat. Hi, Jen. Do you need him to state his name, sir?
Yeah, for Hansard.
For the record? Yeah. Maybe you can do it when I finish. Comprehensive impact assessments of existing trade agreements, including the impact on employment and wages to inform future negotiations, should be part of the process, as should regular and substantive consultation during and between negotiating rounds, the public release of draft texts and proposals for review and comment, and the release of the final text and full and meaningful parliamentary oversight and democratic approval before trade agreements are signed. With regard to impacts of existing free trade agreements, my colleagues will have specific examples, but generally we know that the Productivity Commission has found that predicted economic benefits from bilateral and regional trade agreements were, I quote, inflated, and their actual economic benefits often modest. Balanced studies of the likely employment, social, and environmental impacts of trade agreements before governments make the decision to enter into negotiations are necessary. We have seen over recent decades the significant expansion of trade agreements beyond reduction in tariffs or taxes on imports. And so the demand for a more open and democratic process for trade agreements has grown because they are increasingly dealing with an expanding range of other regulatory issues which would normally be debated and legislated through the democratic parliamentary process and which have deep impacts on Australians' lives. The inclusion of migration issues is a particular concern. The ACTU stresses that migration policy should be a matter determined by democratic parliamentary process and should not be included in trade agreements. We've expressed deep concern with regard to this issue and the Korean Free Trade Agreement and the Memorandum of Understanding that accompanies the China Free Trade Agreement. We've seen agreements expand into the areas of health, social and environmental policy. The Australia Free Trade Agreement, US Free Trade Agreement resulted in changes to patents on medicines, copyright, PBS and local content provisions in government procurement. The current TPP negotiations have an even wider agenda that include food regulation, regulatory transparency, regulation of IT, including electronic data privacy and financial regulation. Proposals for changes in all of these areas would normally take place through democratic parliamentary processes. There is, of course, the extremely vexed issue of ISDS and the direct impact on the ability of our elected governments to actually govern. It squarely places the profits and interests of corporations above the interests and wishes of the people. It is scrutinised by a process that has no independent judiciary, no precedents or appeals, and may well have impacts on domestic court systems. The Howard Coalition Government did not agree to include ISDS in the 2004 Australia-US Free Trade Agreement. The Productivity Commission recommended against it in 2010, and we should not under any circumstances allow our democracy to be undermined in the name of trade. Given these concerns and the broad scope of agreements, it's imperative that transparency and consultation are front and centre. Currently, the consultation process is limited by secrecy. For some negotiations, DFAT hold briefing meetings where questions can be asked, but officers are not permitted to reveal details of any text being negotiated, so answers to questions are limited. There's no way of knowing if concerns of stakeholders have been incorporated or even cared about by the negotiators. Indeed, leaked documents are the only way we get any knowledge of content. The Minister has repeatedly stated that the ACTU is being consulted. This simply is not the case. Whilst consultation with the previous government's minister and the department was welcome, the ACTU was not informed of any DFAT briefings when negotiations resumed on Korea Free Trade Agreement, the Japan Free Trade Agreement and the China Free Trade Agreement after September 2013. In the case of the TPP, DFAT general briefings for the Australian stakeholders were held twice a year, with briefings on particular topics held by request. Still no feedback on particulars of the text were allowed. However, after September 2014, there were no more arrangements for stakeholder presentations for the TPP, and the dates and location of meetings have been kept secret. It is quite disingenuous of the Minister to keep repeating his assertions that the ACTU is being extensively consulted. As you know, the text of agreements does not become public until after Cabinet has authorised the text to be signed. The national interest analysis is prepared by DFAT, who, quite frankly, is not likely to criticise their own document. There's no independent assessment of the economic and social and environmental costs and benefits of the agreement. J. Scott can hardly scrutinise massive and complex documents with the diligence necessary in the time it has, and the committee is hard pressed by its large workloads. And at any rate, we know J. Scott can't change the text of the agreement but only make recommendations about legislative changes. And many items like the important ISDS clause, of course, do not need any changes to domestic legislation. Both the EU and the USA have more transparent and consultative processes, so international precedents exist. And our submission contends that a greater parliamentary role is indeed compatible with the Constitution. Thank you.
Thank you. Who's next?